Good afternoon, everyone. Let me fix that. This is Judge McBurney coming live from an empty courtroom. Looks like everyone is virtual today. I am on for a motion for summary judgment hearing in the matter of Lakemoore Colony Condominium Association versus Ms. Zheng and A2Z Optimization Consulting Networks, although I think the corporate defendant is in default. So I think we're mostly talking about Ms. Zheng and Lakemoore Colony. Can I have the appearance or appearances, looks like we got a few people on, for the Condominium Association?
Your Honor, Dan Wright for the plaintiff. Attorney Omar Cooper is with my office and is observing.
All right, welcome to both of you. And on behalf of defendant or defendants?
Lieutenant Peebles for the defendants.
Good afternoon, Mr. Peebles.
Afternoon.
So where I think we are is this pending motion for summary judgment. We are also on a trial calendar for next week. Obviously, if this motion remains pending, you don't need to come to the calendar on Monday. And if this motion is somehow resolved, it may make the need for a trial unnecessary. I will observe before we dive into the specifics, and I let Mr. Wright take it from here, that I don't get the sense there's a real big argument. Ms. Zheng, from what I've read, tried to pay, it didn't work. She is often absent because her work takes her out of the country, made a significant payment when she realized she was in arrears. And I haven't read anything that says she's not willing to pay the difference, other than that maybe if she hadn't been charged late fees because she was trying to pay, she might actually be owed $500 plus some change. But before we force our way through a motion for summary judgment, I want to make sure that the two sides have actually discussed the possibility of resolving this before they bill their clients more for this litigation. I'll start with you, Mr. Wright, because the way I read this, your client holds the cards. I think, and again, I'll hear everyone out, but I think Ms. Zheng's defense is an explanation, but not an excuse for not having paid. But yet I sense there's a willingness to pay. So why don't you start giving me your thoughts sort of holistically as where we are, and I'll hear from Mr. Peebles. And if we need to duke it out, then I'll hear the motion for summary judgment.
Sure, Your Honor. I think that your recitation of the facts is pretty accurate. This is a case, Your Honor, it's an assessment collection case, not rocket science. But in this case, factually, there are a lot of stipulated facts. There's a lot of agreed upon facts in the case. Ms. Zheng, the defendant, the individual defendant, fell behind on her assessments. She was paying, had it set up. The assessments changed. She wasn't aware of that. I think we all agree that that's, what she says. I have no reason to dispute what she's saying. But at some point, when she fell far enough behind, the matter was placed for collection with our office. We sent demand letters instructing her, letting her know that she was behind and where to make payments. And there was not a lot of communication there that was positive. So, there were no payments made. Well, she claims there were payments made directly to the association, but the association was not accepting payments from her at that time. Usually what happens is when an owner is in arrears, they turn off the access to the online payments so that, the payments flow to one direction, communication goes to one direction. I think that's common in most litigation cases.
Mm-hmm.
So, there were letters sent that told her where she could make payments. She didn't make payments. So eventually the case went to lawsuit. We filed a lawsuit in March. During that time, she allegedly continued trying to make payments to the association, knowing that they were going to be rejected, I would assume, since they had been, and she had been informed of that fact that she was to make payments to our office. We were unable to get anywhere with the case for quite a while. And then eventually she did make a payment in October, and that payment was for $8,036.52. And when she made that payment under the declaration, we applied the payment as per the instructions in the declaration.
Okay, and we'll work through all that. I know there's some argument about that as well, but what I'm hearing is there's not a resolution on the immediate horizon. I also understand Mr. Peebles didn't get in the mix till later. Ms. Zheng for a while was navigating this herself, and that could have added to some of what you're describing. All right, Mr. Peebles, anything you want to add kind of structurally where we are, or should we just get into this motion?
I mean, we made an offer the other day and haven't heard back, but other than that, no, Your Honor.
Okay. Then, Mr. Wright, why don't you take it from here?
Okay. Well, Your Honor, I kind of already started the recitation of the facts. Do you need me to regurgitate those, or are we?
I do not. I do not.
Okay. All right. So there was a payment that was made in the amount of $8,036.52 in October of 2025, some 7 months after the lawsuit was filed. And per the declaration, the payment was applied first to the attorney's fees that were due on the file and cost of litigation, interest, then to principal. At the time that the payment was made, the balance owed was $13,052.09. She made the payment of $8,036.52. That resolved the attorney's fees that were owed in the case in the amount of $2,690. The litigation expenses of $875, court cost of $226, interest of $753.33, and $3,492.19 was applied to principal. So that left an outstanding balance of $5,015.57. And after that, we filed the motion for summary judgment for those amounts. Obviously, the burden is on the moving party, who's the plaintiff in this case, to establish that there is no genuine issue material fact and it is entitled to judgment as a matter of law. And as we said earlier, Your Honor, there's a lot of facts in this case that are stipulated that defendant is the owner. And when I say defendant, I am speaking to Ms. Zheng in this context, as she is the main defendant who's not in default at this point in time. But the defendants are the real owners of the property that's located at 319 Lakemoore Drive in Atlanta. Assessments accrued upon the subject property owned by the defendants. Plaintiff is entitled to levy assessments upon the subject property. The declaration provides that each owner of the property, subject to the declaration, by accepting a deed to the property, covenants and agrees that they are liable for their share of the common expenses. Pursuant to the declaration, the deed renders the property subject to the declaration. And then, again, pursuant to the declaration, the defendant, or the association is entitled to recover interest, attorney's fees, and court costs if there is a balance owed by the owner, in this case, the defendants. And pursuant to the declaration, past due assessments, late charges, interest, and reasonable attorney fees and expenses actually incurred constitute a lien against the property. So there's also been a foreclosure sought in the case, and notice of that was provided to the defendants, as well as the plaintiff's intent to accelerate the assessments due from the defendant for the fiscal year. I think that's kind of the extent of where we are as far as the stipulated facts or the agreed upon facts. And I believe that that is sufficient to establish a prima facie case for the defendant's right or the plaintiff's right of recovery in the case. The defendants have filed a response through Mr. Peebles, in which he raises a case that is similar to the case we have here, Ballard versus Biltmore. In that case, there's a similar fact pattern, but unfortunately, there's not a very in-depth analysis of the facts in this case. In this case, there were a similar fact pattern where an owner was sued for assessments. They made some payments. The payments were applied throughout the course of the relationship of the parties, and the court found that by the association in that case applying payments, partial payments toward the attorney's fees, there was a genuine issue of material fact. In that case, Your Honor, even though it is similarly factual, I think there are some big differences in that case. In that case, there were over $40,000 at stake. There was $50,000 in attorney's fees over the course of many years of litigation. That, you know, threw a lot of uncertainty, I guess, at least in the eyes of the Court of Appeals, as to the attorney's fees. In this case, Your Honor, the defendant failed to pay the full amount of her assessments. Again, I think that's agreed. I don't think that there is any dispute there. And this put the defendant's account into default, and the owner was turned over to us for collections, and the account was blocked. It's very common to do that. So payments that she made through the portal, so to speak, would be returned to her or just rejected, not accepted. When the case was sent to us, we sent her a letter on August 5th of 2024 and October 7th of 2024, directing payments and communications to come to our office. That didn't happen. So at this point, we were not necessarily aware that she was trying to make payments to the association, but nonetheless, they were rejected. However, she did know where to make payments. She was notified of that. Suit was filed in March of 2025 after the owners did not make their payments, and continued to refuse to pay our office. And then once the defendant finally did make a payment in October of 2025, it was applied exactly as the declaration states. You know, that we're supposed to apply the payment. So in that case, the plaintiff is just following the governing documents of the association.
The amount that was paid in October of last year, was that equal to the assessment arrearage?
It was close, Your Honor. It was a little bit less. It would have been, let's see here. At that point in time, the assessments, the principal that was owed was $8,507.76, which it does include some late fees. And then the defendant, Ms. Zheng, paid $8,036.52. So it would have been close. Yes.
Okay, got it. But it didn't whittle down the assessments as much as she would have liked, because some of it was applied to these other costs that the association had incurred. You've said several times that's consistent with the declaration. I've got the folder open that has your affidavit and your motion. Where in there could I find the provision from the declaration that says, hey, if someone makes a payment late, the association can use it to pay off attorney's fees before it pays down the assessment balance?
Certainly, Your Honor, that'd be section 10 of the declaration, which begins on page 009 of the declaration, the recorded declaration.
Is that part of your complaint? I need to know where the declaration is.
There's a copy of the declaration that is attached to the affidavit of Sarah Howland.
Okay. Oh, that's why it's so big. Okay. And now I'm in it. You said page 009? Yes,
sir. That's where it starts. And then going on over to page 10.
Yep.
That would be section 10C, delinquent assessments, and then below that in section 2, that says, starts off, if part payment of assessments and related charges made, the amount received may be applied respectively to.
Okay, I see it, and it's may be, so it's at the discretion of the recipient of the funds, meaning the association, and they may apply it to unpaid late charges, specific assessments. B is reasonable attorney's fees, et cetera, et cetera. Okay, so it gives the association the option of picking which amounts they are paying off.
Yes, Your Honor. It does use permissive language may be applied, and that's exactly what they did in the case. Typically, the association is most inclined to go with what the declaration says to avoid any kind of appearance of selective enforcement or anything like that. But they were applied in the manner that we see here. Basically, first to attorney's fees, cost of collection, court cost, interest, and then principal.
Okay.
All right.
All right, back to you. Thank you for answering me.
Yeah, so again, as we were discussing earlier, that left a balance of $5,015.57 after Ms. Zheng's payment was applied. Again, there are, the case submitted by and relied upon by the defendant, Ballard versus Biltmore, has some similar facts to it, but I do think that it is distinguishable. In the case, it's my understanding in that case, this was a case that drug on for years. There were multiple payment agreements, multiple payments made over, like I said, course of several years. It's not really the case here. We have a much more simplified fact pattern here that I think is borne out by the affidavit of Ms. Holland and my affidavit. So I don't think that there is a particularly extensive controversy over what was owed, as far as at least what the association has put forth into the evidence as to what was owed and what was paid and what remains owing.
Okay.
And the Court of Appeals found that the issue and the fact remained because there was not, maybe the court in that case didn't make a determination the attorney's fees were reasonable or had not yet made the determination. Judge Adams in that case assumed that by granting them the motion for summary judgment did find the attorney's fees that were incurred in the case to be reasonable. But I don't have that from the fact pattern that was put in the opinion of the Court of Appeals. But again, in this case, there was only one payment that was made well after litigation started. So I think it's a pretty simplified fact pattern that we're dealing with here, where the court could look at the payment that was made, look at the attorney's fees that were incurred and that have been made a part of the record by my affidavit and my attorney's fees expense reports. And like I said, because the court in this case can see exactly how the attorney's fees charges were, billed to the account and how the payment was applied to those charges, I think the court can make a determination in this case that the attorney's fees were reasonable in the case. So I don't think that in this case we have a genuine issue material fact as to the attorney's fees or how the payment was applied. Again, when we go through all the facts that have been stipulated to, I know most of them we like to say, if a balance was owed, I don't think that there was, at least at the beginning of this case, any dispute there was a balance owed. It was just a matter of how she took care of it eventually in October. I guess knowing all along that her payments were not being accepted, at some point, her making those payments is pointless. And as for, she was notified as to how to make those payments and she just didn't. So I don't think that that's a valid argument for why the payments weren't made. But when those issues are considered by the court, I think it is a distinguishable case from the fact pattern of the Ballard and Biltmore House case that the defense cites. Again, like I said, we have a lot of undisputed facts here that the plaintiff's entitled to levy the assessments. The defendant failed to pay the full amount of the assessments. Under the declaration that the association is entitled to recover its expenses, your cost of collection, interest, late fees, and attorney's fees, and that the declaration prescribes, how those partial payments can be applied and should be applied. The plaintiff applied the payments pursuant to the rights given it under the declaration, and a balance of $5,015, still remains due and owing from the defendant through the end of 2025. Also, I think when you look at how the court decided Ballard versus Biltmore, I think you have to also balance in there that there are numerous other court opinions that are, obviously in my estimation, far more favorable and have been around a lot longer and have more case law to them than the Ballard and Biltmore case. Forest Villa versus Camaro, which is cited in my brief, states there's no legal justification for a lot owner to fail to pay valid assessments. In this case, there's valid assessments out there. Her not, having payments or not wanting to make payments to my office is not a valid defense to that. You know, We Hunt versus Wren's Crossing, condominium association, as to amounts of attorney's fees is also a seminal case in this area of the law. In that case, Your Honor, it's also cited in my brief, found that, in a case that where there was $900 in principal owed, $9,000 was not found to be unreasonable. That award was upheld by the Court of Appeals. So I don't know that it's necessarily in Ballard that it was the amount of the case. I mean, maybe that was one reason that they weren't sure as to the reasonableness of the fees and kicked it back to the trial court. But again, we don't have a really robust factual record in that opinion. And then lastly, Judge, we do have the declaration in the Georgia Condominium Act that provides the associations a title to the attorney's fees that they sought. So there has been evidence placed in the record with my attorney's fees bills, my testimony as to the reasonableness of the attorney's fees. I think that there is plenty in the record for the court to find that those fees that have been incurred are reasonable, and that the defendant still owes for the amount that we've sought in our motion for summary judgment, $5,015, and what was that? 57 cents. Sorry. So with that being the case, Your Honor, I do think that there is no genuine issue material fact that's remaining in this case. I think that the plaintiff has established that it's entitled to judgment as a matter of law, and I'd ask the court to enter summary judgment in favor of the plaintiff.
Mr. Cooper, anything you want to add, or did Mr. Wright do an okay job? All right, there you go. Mr. Peebles, I'd love to hear from you, the defendant's perspective on this.
Yes, Your Honor. Once Ms. Zheng paid the arrearage and caught up the amount that was due in August of 2024, there's no reason that the case should have still been in collection at his office. And therefore, there's no reason the association should have rejected the payments, because she was caught up at the time. She wasn't behind. The reason this case got filed is because the payments got rejected month after month, and then they looked at the balance, and now there's a balance owed because the payments weren't coming in for August, September, or I guess September, October, etc. And so the reason it's unreasonable that this case was filed was because they unreasonably rejected the payments. My client actually emailed Sheila Vernon at the association telling her she would be increasing the automatic payment every month starting in September. The reason she was behind in August of 2024 is there was a change in the monthly payment, and she didn't realize it. So every month she was a little short, but she made that up in August and increased the automatic payment in September, but it kept bouncing back, and she didn't notice, unfortunately. But we would argue that that it wasn't reasonable to even file this case, because there's no reason the case should have still been at his office under collection status, because she was caught up. Now, the case I cited, Ballard v. Lakemoore, the main point of that is if they apply payments to attorney's fees first, any of the attorney's fees are deemed to be unreasonable, then summary judgment can't be made, because the whole thing has to be recalculated. And that's what we argue today, that because there's no reason to even file this case if they had taken the payments as they were paid, then that deems all the attorney's fees unreasonable, really. Because they never had to be incurred. The Condominium Association documents, the Declaration of Condominium, don't give a blank slate to the association to pursue any type of litigation at all. Rather, it has to be reasonable considering the goal of the association to collect its assessments. And so for that reason, would ask that summary judgment be denied.
All right. Thank you, Mr. Peebles. I've got a couple questions for Mr. Martin. Mr. Wright. Mr. Wright, but I'll turn back to you, Mr. Peebles, if you have things you want to add after you hear his responses. Mr. Wright, I am focusing on August of 2024. It sounds like everyone agrees that that's when Ms. Zheng realized that there had been an increase in assessments, and that she had been inadvertently underpaying. She was paying routinely, but it was that same old $342.52 amount, and it had gone up by looks like almost $80. No, $120. Woo, that's a big increase. So there was this extra payment made in August of 2024, $944.56. Couple questions about that. Did that amount, according to the ledger you've got, bring her balance to zero? You're on mute.
Sorry, Your Honor. No, it didn't. In August of 2024, you can see on Exhibit C that's attached to Ms. Holland's affidavit.
All right, let me get there. Because B is so long. There we go. Nope. There's B, C. Okay, I'm looking at the ledger.
And in August of 2024, you'll see in the payment column that there was payment total credited $1287.08, which included $944, I believe it was, that she paid.
Yep.
It left $301.36 in principal, and there were also attorney's fees for the demand letter that she had received before that payment was made, which she didn't pay. So that's why the account remained in collections.
Where do I see the attorney's fees predating August? Where would I find that on the ledger?
Let's see. It would be in my. Oh, hang on a second.
Because there are attorney's fees on this ledger.
Yes.
2,690, but there's no date associated with them?
I have on my Exhibit A, Your Honor. And actually, though, it does show that I think that it's actually missing. But it's dated October 3rd of 2024. That was the first demand letter that we charged the client for. As you see, there's $395 there, but the first demand letter was sent out on August 5th of 2024, and there was no charge to our client for that letter at that point in time, but there were other attorney's fees and other charges that were not taken care of by that payment.
Okay.
As you can see, there were 300. The full amount of the payment that she made was applied to principal.
Right.
And there was still $300 left. So she still had.
Because there was an addition. I see. Because she paid $1287, and the balance from the month before was less than that. But you got to add on another $460 because they're the monthly assessment. And so that I see. Okay. So even without attorney's fees, there, according to this ledger, which there would still be a balance remaining.
Correct, Your Honor.
Okay. And that payment was accepted because it shows up in that column, the $1287.
Yes.
And then it was in September of 2024 that your client ceased to accept payments through what I'm going to call the traditional channel. I don't know what it was, but however Ms. Zheng was paying, it was going through. Yes. And then it stopped in September, and she knew that how?
Well, it was most likely in August when it was turned over. Typically, when a case is turned over for collection is when they disallow access to the account online.
But one way I understand you allege she knows is that if she looked at her bank account, she would see that these monthly amounts are bouncing back. Pretty noticeable. If you send $460 and it bounces back. So that's one way. But you mentioned a demand letter and you said it's turned over to collections. Is there something in the record that shows that your firm or a collection agency or the COA sent an email or a letter or something to Ms. Zhang saying, don't use this channel anymore. If you want to pay anything from this moment forward, it goes to Lazega and Johnson.
Yes, sir. Johansson, Your Honor. But there was a initial demand letter of August 5th that went out to the owner. And then I know that I do not believe that was attached to our complaint, but the October 7th, 2024 demand letter, which is our second demand letter, was attached to our complaint. And in that, it gives notice of our intent to foreclose and to accelerate her payments. And at the bottom, please be advised, it also states, please be advised that any and all further communication regarding this matter should be directed to our office. Please do not contact any member of the board of directors of the association. And then as a convenience to you, it gives you multiple ways, whether it's online or our address to make payments.
Okay, I see. It's the final paragraph of that letter. Check or money order to a PO box, debit or credit card, no service charge.
Service charge.
Okay.
And
and
I
then,
don't like that, but
yeah, I bet. And then there's even a payljlaw.com.
correct, Your Honor.
Got it. So, and this is not just something you popped in the mail, but it's certified mail that would have gone to that Lakemoore Drive address.
Well, and it also went to the 384 Braxton Place, Tucker, Georgia address, which was the registered office, at least at that time, I believe, of A2Z. And I believe that's also Ms. Zheng's personal address as well.
Okay, got it. I see that as well. Yeah, there are a bunch of copies of this letter. Okay. All right. So at least as of October 7th, 2024, Ms. Zheng and the corporate entity were on notice that payments needed to go a different amount. There's a past due amount, and there are also ways to reach you or Ms. Irving to talk about how to sort this out.
Correct, Your Honor.
Okay. And you didn't receive any outreach from Ms. Zheng?
Well, no, Your Honor, there were some communications, just no payment.
Okay. Got it. There were conversations. I mean, ultimately, there was this $8,000 payment. That's a ways down the road.
Another year, Your Honor.
Right. But at this point where things were shifting from you auto pay through your bank the way you have been to, nope, now it needs to go through Lazega, there weren't payments made. There may have been some contact, but no payments made.
Correct, Your Honor. Until the October 2025 payment.
Okay. If they had been made, let's say in December of 2024, Ms. Zhang decided, let's just sort this out. And so I'm going to send $2,000. Would there be an entry on the ledger that is Exhibit C?
Yes, Your Honor.
Even though it didn't go through the normal channel?
Oh. Well, no, because we did not receive the payment. We don't have any way of knowing if a payment has been rejected, if it's been returned. Our office has no way of knowing that.
No, if she had sent money to Lazega as instructed in the letter, the October letter, but she did it in December of 24 and said, you know what, it's in the year, I got a bonus, I'm going to try to pay all this down. And she sent $2,000. Would there be an entry in the ledger?
Yes, Your Honor. Had we received payment, we would have recorded it on the ledger.
Okay. The ledger, though, is what you keep, or it is what the accountants for the COA keep?
It's part of both. There are two separate issues. It's in this case, it's a compilation between their records because their records don't always include the attorney's fees and things like that. And then we integrate that to use as a way to keep track of what the defendant owes.
Okay. All right. Mr. Peebles, anything you want to add in connection with the questions I was asking about this transition from being able to pay through the traditional route and shifting to having to pay Lazega and Johansson?
Yes, Your Honor. This October 7th, 2024 letter does not specifically say you can't make the payments through the traditional route. It says that they offer multiple options for payment, and the list the PO box or the pay LJ law. It doesn't say you can't make the payment through the usual means, and I think it'd be reasonable for somebody to read this as these are since it says multiple options for payment, that these are additional options and that you can still make payment through the traditional means. It does not say you can't. And so I don't think that's a clear notice that you can't make the payments through the traditional means. I don't think this letter would be clear notice of that, Your Honor.
All right, thank you for that. I hadn't noticed that in the letter. I think you're right. It says don't contact the board of directors anymore. If you have communications regarding this matter, direct to our office. That is a little different from saying stop paying the way you were paying. The only way you can pay is through one of our multiple options. Okay.
This isn't related to this argument necessarily, Your Honor, but if the case were to go to trial next week, I would request my client, who's on the Zoom under Samsung right now, be able to attend by Zoom. She recently suffered a skiing accident, and is not very easy to get around right this second. So, but that's all. Thank you.
Okay. Mr. Wright, if we do end up going to trial next week, since I've got everyone on this call, do you have any objection if Ms. Zheng participates virtually rather than being in person?
No, Your Honor, I don't. I would also have, if we end up going to trial, would have one request as well. It's just that I do see that you have a week listed. It's just that it not be Friday. I do have something scheduled out of town on Friday, if that's at all possible. I don't think that this will be a very long trial, so we could fit it in somewhere else during the week, if at all possible. Or if the court wants to, it doesn't get reached this week, then I'm fine with trying it down the road. But if it's going to be next week that we end up going to trial, I would appreciate it. The court's consideration if it just wouldn't be Friday. Put it that way.
Sure, I'm happy to accommodate both those requests. Ms. Zheng can appear virtually, and we won't do Friday. I know we just did the pretrial order. Both sides agreed that if it's a trial, it's a bench trial.
Correct.
Okay, great. Then my expectation is that unless I get you an order on the motion for summary judgment that grants it, that counsel will be here Monday morning. So you don't need to worry about Friday. I need the lawyers for all the cases that remain, and they are dropping like flies on the trial calendar, to be here Monday morning so that we can figure out where we're going to place each thing. For example, Mr. Wright, I would know, since you shared this, hey, don't save Lakemoore Colony till Friday. We'd want to pop it in somewhere else. And I just don't know enough from the few remaining cases. There's one that could be a jury trial. That would not take all week. And so maybe we pick a jury on Tuesday and we do this one on Monday. So I'd ask you all to be here Monday morning at 9, which is what it says on the trial calendar, ready to go. Because as I look at the different blocks, it could be that it makes sense to do this one on Monday morning. But I won't surprise you and keep you on call. We'll decide Monday morning the way we're going to spend the week. And so if we don't handle this Monday morning, you'll know, hey, it's going to be Wednesday afternoon or Thursday morning. I'll give you that certainty. You won't be on call. I just, like I said, don't know what's happening with the few other cases. And so I can't say, hey, you're the only one left. Excuse me. Of course, you'll go Monday morning. So again, if I look over this and conclude that summary judgment is appropriate, people do not need to be here Monday morning. You will work through, in light of summary judgment, is Ms. Zheng going to try to work something out, short of foreclosure, which would be great. If I deny summary judgment or it's only partial, then I need you all here on Monday morning. Does that work for you, Mr. Wright?
Yes, Your Honor.
Mr. Peebles?
Yes, Your Honor.
Great. Then that'll be the plan. Ms. Zheng does not need to be here Monday morning. If we do go forward, we'll set up a Zoom link so that she can connect with that. She will need to be visible. It's fine that right now it just says Samsung, but she needs to understand that if she's testifying, everyone's going to need to see her. It's not going to work to have it be audio only.
Yes, Your Honor, I'll work with her to.
Okay.
Working.
Your Honor,
Sounds good.
One more question for you. Something that I have not had much experience doing is if we do proceed to trial, I noticed in your trial notice, it references using Zoom to share our exhibits and things like that. Does your court have any idea about, if we're going to be there in person, we're still going to use Zoom? Is that correct?
Yeah, and all that means is that the evidence presentation system we have an overhead projector, but otherwise it's a little bulky. I wouldn't bank on that working. The way we do it is we set up a Zoom call, and every screen in here is connected through something called Zoom Rooms. And so you bring your laptop and you pull up on the screen. I mean, I'm going to do it right now. This is what you would do. Judge, I want you to see the letter that we sent on October 7th. And you can see on your screen right now, there's that letter. And if you are agile with it, you'd say, look, I want to highlight this paragraph right here. That's the one I want you to look at. I don't require you to do call outs like that, but that's how we share evidence. You're welcome to have hard copies because this may be a small group. It's not a jury. I'm fine with hard copies if it is you and Mr. Peebles and myself and my staff attorney. We can all look at the piece of paper, but that declaration is a whole bunch of pages, and you might not want to make 5 copies of the declaration. If you've got it on a PDF, which I know you do because you attached it to someone's affidavit, then you would simply have your computer connected to the Zoom call, and you would say, I'm going to share my screen now. Here's the exhibit I want you to look at. It's the declaration. Look at section 10, sub C, sub 2. That says that the COA can pay off the balance as it sees fit.
Okay. You are okay with us bringing hard copies as well?
I am. Old school works. It's really up to you. If there's a jury, that doesn't work. But with just us, that's fine.
Okay. Thank you very much for that clarification.
You bet. Any other questions, Mr. Wright, from plaintiff's side?
No, Your Honor.
Mr. Peebles, anything logistically from your client's side?
No, Your Honor. I'll work with her on her camera and have any exhibits she needs to look at on digital format.
Sounds good. Thank you, everyone, for dialing in.